Gazelle.
Thank you, Mr. Chairman. This bill, as my colleague has said, was introduced into this Parliament quite some time ago, 9th of July 2008, in fact, when the Honourable Judith Tizard's name was on the bill as an Associate Minister of Commerce. I, of course, was the Minister of Commerce at the time. When the bill was referred to the Select Committee, though, I was no longer the Minister of Commerce. I was in fact the Chair of the Select Committee, and I'll take all of those encouraging words that I just heard from the Honourable Trevor Mallard to be an endorsement of my chairmanship of that particular committee, and I want to in turn acknowledge Claire Curran, who actually acted as a very strong liaison person with the range of interests that were needing to be heard. And I think when the original set of submissions were heard on it, we were left with the position, and we had a very good meeting with Simon Power, who was the Minister at the time, which basically gave us the comfort that the position that we would ultimately adopt would be one that would be acceptable to the government. He was very accepting of the fact that we were engaging quite appropriately with the wide range of interests who were expressing quite strong views on both sides of the argument, and I think we came to a very good position, and we did so in a very robust way. It was of great disappointment, I think, to both Claire and myself that we ended up in a situation where a new minister, a fresh minister, having another look at the legislation, decided to overturn all of that good work and thereby create exactly the same environment that we had confronted when we heard the submissions. And I just want to comment on this because I'm not going to be here for very much longer, and so it's an opportunity just to say that when I was a minister, I found by allowing the Select Committee to have the leeway to work closely with officials and to even meet offline with people who had very strong interests, it actually enabled people to reach sensible conclusions. And there is no need sometimes to stick to a formatted process just because that is the way things are always done. Sometimes things get missed in the toing and froing, and sometimes it's actually better to get people to go offline and have these conversations and to show a bit of trust. And I think that trust was certainly experienced with Simon Power as the Minister, and then I felt myself as the Minister I had that relationship with him, and then afterwards as the Select Committee Chair, again very much the flexibility from that particular Minister to enable the officials to also go offline and to have conversations with the people who were making submissions. So I really want to kind of endorse the process and invite the Parliament to think very carefully, because I do notice that we've had a letter for an update of our standing orders, and it may in fact be worthwhile having a look at that, because at a Select Committee hearing, during the Select Committee process, you can't provide briefings to people that are not members of the committee. Well, you can to other MPs, but you can't provide briefings outside unless there's a report to the House, and then that enables information to be made publicly available. And I think that some of these rules could actually be looked at if it is done by agreement. It seems to me that the standing orders of the Parliament would be improved if in fact our Select Committees were able to facilitate that level of engagement with the officials and the protagonists, but it is in relation to this one clause that is in Part 1. And it is absolutely related to that, because the supplementary order paper, which brings in the definition of computer program, is in Clause 10A, which is in Part 1, and that's why I think that it's absolutely critical. Because what we ended up seeing was that the Minister himself, obviously in a process, went offline as a new Minister, and then came back with what was, Mr Chairman,
The Honourable Leanne Delsey.
what was in fact an unacceptable option, and without discussing it with the members of the Select Committee that had, well, it's the Minister who's in the chair now, and I don't know why that happened, but putting that example, well, putting that particular clause out into the public arena as a supplementary order paper caused a furore, because there really had been an acceptance that we had reached a good decision, we'd used a good process to get there, and the Select Committee had actually contributed, I think, very positively to this bill. Now, and I think that what the Minister's unfortunately done is by going down this pathway, and it actually picks up what Trevor Mallard was saying before about the timetable, about, you know, he hadn't seen this particular piece of legislation since it had Simon Power's name on it. In actual fact, this could have been dealt with a lot sooner, and the legislation could have been passed and in place prior to the 2011 general election, and I think that would have been incredibly helpful to have that matter resolved. Although, admittedly, he didn't take over that role until after the 2011 election, but here we are in 2013, and we've wasted literally 2 years of the bills, well, of our time generally to update patent law. The legislation itself obviously has lots of different provisions within it, but because this particular provision is so important to where we get to in terms of the IT sector and the definition that the legislation will now contain, and I've got so many supplementary order papers here that I'm just trying to find the exactly the correct one that has the new wording in it, which is a computer program is not an invention for the purposes of this Act. Subsection 1 prevents anything from being an invention for the purposes of this Act only to the extent that a patent or an application relates to a computer program as such. Now, the wording as such is still there, which is not as helpful as it could have been, but it is better than the previous wording was. And what this will do is that it will enable, and the one example that we kept coming back to at the Select Committee was what we called the Fisher and Paykel example, where the particular embedded software within the machine itself is not a computer program in its own, well, it is a computer program, but it's not. It is the purpose for patenting it is for the machine, the washing machine, the type of washing machine that it is, rather than the software process per se. So I suppose that means as such, doesn't it? The mere and but what it does mean is that the mere execution of a method within a computer does not allow the method to be patented, and I think that's the core difference with respect to the wording that's finally been agreed. So I think that we're all on the same page. This is essentially what the Select Committee agreed to do with slightly different wording, and we could have avoided the significant level of delay that has been incurred if we'd been able to get together and probably resolve these issues before it came out the way that it did. So I think it's kind of a warning to others who are in this situation when there are, you know, competing interests. And then I think allowing the Select Committee, trusting the Select Committee to play a role in terms of seeking to broker a compromise is actually not a bad thing to do. But then when you've trusted them to do that, please let that continue and don't try and overrule it without going back to to essentially the people that brokered that compromise. And sometimes legislation will be compromised if you've got really strong competing views. Sometimes there is a way through the issue, as I think we found on this particular case. We were all on the same page, and it would have been helpful if the Minister had decided to join us there much earlier.
The Honourable David Parker.
Thank you, Mr Chairman. I'll make a brief contribution to this part of the debate. Mr Chairman, I think as the Minister and most in this